XRP holders have been tested. We all can agree. But there is a possibility of one more gigantic test. If the judge says, motion for summary judgment of the SEC denied, motion for Ripple for summary judgment denied. At this point, I don't think it's going to happen. I know I disappoint a lot of people when my opinion is that there will not be a settlement. That case is useless.
In today's video, attorney John Deaton discussed the latest with the SEC Ripple XRP lawsuit, the recent summary judgments from Ripple and the SEC, and what's next for the procedural process. Before listening to him, please ensure to smash the like button and subscribe to the channel.
There was a lot of questions that people wanted to get your thoughts on Ripple and the case there. When we may see summary judgment, and if judgment is passed, can the SEC appeal?
If the judge was going to hold an oral argument, chances are she would have held it by now. You know what I mean? Also, she doesn't hold an oral argument unless the parties ask for it. And I can't remember whether Ripple and the SEC, when they filed their summary judgment, if they then, asked for it, because her local rules, when you file a motion, you have to send her an email that says you want an oral argument. There's a good chance that Ripple didn't ask for an oral argument because they just want to rest on their papers, right? And the SEC may not have asked for it. And so I would say at this point, although I'm surprised she didn't have one because of a case of this magnitude, to flush out some arguments, maybe cross-examine the attorneys on why. I would have loved to seen her reaction to the SEC's theory. It keeps changing, you know what I mean? But at this point, I don't think it's going to happen. Oral argument. Yes, each side can appeal. So, I know I disappoint a lot of people when I said that my opinion is that there will not be a settlement before a summary judgment ruling. But often what happens is when you get a summary judgment ruling, then there can be a settlement. So let's say that Ripple, let's say they just flat out win, right? The SEC could say, well, if you agree to pay a fine for some early sales and the judge gave you what you wanted, XRP is not a security moving forward, we won't appeal it. So Ripple could say, well, we want the finality. Here's a $25 million fine, and there's a settlement. If the SEC, if there's a split win where the judge says, Ripple violated this, but XRP is not a security, there could be a settlement. The real danger, Tony, and it's something that would probably really, really test. XRP holders have been tested. We all can agree. Their patience has been tested like no other token holder. But there is a possibility of one more gigantic test. And that is if the judge says, motion for summary judgment of the SEC denied, motion for Ripple for summary judgment denied. A jury must decide certain factors, right? Was there non-investment use for XRP? Is there a common enterprise that exists? Like she could, and I can't tell you what those chances are for that because a lot of the evidence is still sealed, right? And so I don't know what both sides agreed upon. Usually in a securities case, both sides will agree with enough facts that you don't need a jury to decide because they're in agreement of the facts, of enough facts that the judge then says, okay, there's no need for a jury. These are the facts, and I can apply the law and render a decision. But if there's enough disputed facts between the parties, then there would be. Also, Ripple in their papers stated that whether or not Ripple received fair notice is a jury question. Now, most people don't want the judge to get to fair notice because if she gets to fair notice, she found XRP to be a security at some point, not the token, but that Ripple used it.
Right.
And now the fair notice is, well, we should be excused from it. And so, so there is that danger. And I've went on record to say, not enough people, a lot of people are underestimating the chance. I don't know what the chances are. I don't remember what Jeremy Hogan, I know he did his percentages, and I don't know where he put a jury trial at, but you know, it's not 1%. It's higher than that. You know what I mean? So if there's a jury trial on something, then we could get no clarity because a jury trial has to happen. The class action, a handful of people, one guy filed a lawsuit in May of 2018 against Ripple, and he claimed that XRP was a security. That guy, his case was dismissed, but he had only held XRP for like a couple days. He lost like $180 or $160 or something. I don't know. But there were several other lawsuits that filed, people claiming the same thing. And a class action is just like what I filed against the SEC was I named, 6 individual XRP holders, but then I said, and all others similarly situated. And so we have 5 or 6 individual XRP holders in California court who are saying that XRP is a security, that when they bought XRP, it entered into a common enterprise with Ripple, and that they were relying on the efforts of Ripple and they lost money. Well, the problem is, and Ripple is going to file their objection today, but that attorney has moved the court, filed a motion to have the class certified. And there'd be a certified class action instead of what's called a putative class. It's a certified class. The problem is the lawyer says that this individual XRP holder is going to represent, quote, any XRP holder who purchased XRP in May of 2017 until today, who either still owns XRP or lost money. So that individual saying he represents Tony's mom, and the 75,000 people who have said the opposite. And the problem is they didn't limit. I wouldn't get involved if they were just saying any XRP holder who purchased from Ripple or its executives. Right? Then I got nothing to say. I wouldn't have been involved in the SEC if they'd have done that. I wouldn't have been involved in library if they'd have done that. But this plaintiff's attorney is saying all sales of XRP are securities. He's doing the same shit. Yes. Secondary sales, the token itself. So he's saying the same exact shit that the SEC was saying. And so I am going to object on behalf of XRP holders that this guy is not a representative of Tony's mom. He's not a representative of my daughter. He's not a representative of the 6 XRP holders who were in the Ripple case, right? And that we have 75,000 people who say the opposite. How many does he have? Because I've only counted 5. And so I just want to let the judge to know that that is too overbroad. In other words, it's the same thing the SEC is doing, except it's a private person doing it, and that I want her to know about it. And this judge could say no to me, could listen to me, who knows? But we have to fight the token itself being called a security and protect secondary market sales, whether it's the government or an individual. If you bought XRP and you held it for 2 weeks and sold it, then how are you relying on the efforts of Ripple? Let's just talk common sense. Like, by definition, you're not relying on the efforts of Ripple. You didn't give them enough time, right?
Yeah.
Like if you were still holding it for 5 years, right? Saying, I want Ripple to fulfill a promise, and you bought it from Ripple, then I wouldn't say anything. I might disagree with you and all that, but I wouldn't get involved. But if you're going to, say, I bought XRP on Monday and on Friday I sold it and I lost $60 and I'm pissed off at Ripple because they didn't, and, I relied on them, then, that doesn't pass the laugh test.
Okay.
And, all I can tell you is it is very suspicious of the timing of this lawsuit, but the bottom line is I'm representing XRP holders, not Ripple. So I'm going to say the same thing. Tony, I'm very consistent. I'm going to say the same thing. If you got a problem with Ripple, fine. Keep it to Ripple. Leave us out of it.
Yeah.
Right? Quit claiming that what I own or what you own in and of itself is an unregistered security. The facts don't support it, common sense don't support it, and a century of case law doesn't support it. So stop doing it. But there's lots of agendas at play here. And on top of that, the final thing I say about this private class action is, if the SEC wins, that case is useless, because you can't. If the SEC wins and collects $1 billion from Ripple, they're going to create a trust, right, and try to reimburse XRP holders. Well, that civil lawsuit, you don't get to double dip. You don't get to say, oh, we get $1 billion too, and we're gonna give. So it kind of makes no sense, like that they wouldn't wait until the result of this case. And so all I want to do is say to the judge, we're a few months away from a decision. This case was filed in 2018. It can last. It can wait a few more months. Let's see what the judge says. If the judge agrees with the SEC, then, whatever, and you want to certify the class, go ahead. If the judge comes back and says direct sales only, secondary market sales are not in play, like the library judge, then that will affect this civil lawsuit as well. You would think, right? And so, but that's the problem, is that it's just overbroad, way overbroad.